Josh Antis. I'm in the Community Relations Department here at California Coast Credit Union. And again, welcome. Thank you for joining us today. We have some really great information to share with you. Before we get started, though, we have a large group today, so everyone will be placed on mute for the duration of today's presentation. However, if you do have any questions, please feel free to ask those in the question and answer box or in the chat box. We'll be taking a look as we go and answering those questions for you. If there are any questions that are a little more involved, a little more detailed, we'll most likely answer those at the end. So if we don't answer it right away, don't worry, we'll get to it. And then today's session is being recorded. So if you want to go back and get any of the information we talk about, if you missed anything as we go along, don't worry, we're going to have it up on our YouTube channel tonight so that you can check it out. And I will put the link in the chat so that you have a direct link to go and take a look at the recording. So with that, I think I will go ahead and introduce our presenter today. We have Patrick Hicks from Trust and Will. He's general counsel over at Trust and Will, and he has presented for us before. We're excited to have him back, and he's going to talk to us a little bit about estate planning. It's quite a daunting task when you first look at it, but I think he's going to make great sense of it for us, and he's got a lot of great tools and resources to share as well. So happy to have you here, Patrick. Go ahead and take it away.
Thanks very much, Josh. I appreciate everyone making the time available. I'm always happy to talk about estate planning today. Well, really any day, but particularly today, share a little bit of information with you and hopefully get you started with what you need to know about your own estate planning and what you might want to consider when putting an estate plan together. So again, I want to just reiterate a little bit what Josh said. I'm Patrick Hicks. I'm General Counsel of Trust and Will. We are very happy to be presenting this webinar today with Cal Coast Credit Union. And there's a picture of me, which every webinar should start with, I believe. But we have a packed agenda today, and we're going to really discuss the basics of estate planning. And we'll start by giving you an understanding of, really what an estate plan is and what it does. And then we'll cover some of the key documents that might be included in an estate plan and help you decide which of those documents might be best for your particular needs. We'll then discuss who needs an estate plan and some of the common reasons it might be time for you to either create or update an estate plan, and go over a bit how you might get started with that process. And we'll also make sure that you know where to turn if you have any questions about your estate planning needs. We do have some Trust and Will experts here with us today to help with any questions you have along the way. If you see on your screen, you should be able to click and open a Q&A panel. If you have a question, ask it there. We'll do our best to answer it as we go. And then as time allows, we'll make sure to answer any questions we have at the end. But again, we will cover how to get help with any questions that don't come up today or don't get answered today to make sure that you know where to turn if you do have any additional questions. So that being said, let's get started. We can dive right in. So what is estate planning? We've all heard the term, but really, what is that? What does it really mean? Estate planning is planning today for what happens tomorrow. At the most basic level, an estate plan lets you make decisions for what should happen if you are unable to make decisions in the future. It's a set of instructions where you can say what you want to happen in the situation that you cannot speak in the future. So why should people care about estate planning? What motivates someone to create their estate plan? This is really one of my favorite questions, and that's because there are so many reasons to care about estate planning. The biggest reason for many people is simply peace of mind. Having an estate plan can give you confidence that you have taken steps to protect yourself and to protect your loved ones. You can rest easy knowing that you've put a plan in place and determined what should happen if things go wrong, if the unexpected happens to you. Having a plan also avoids leaving your loved ones with no guidance during a difficult time. Before joining Trust and Will, my career was an estate planning attorney. I worked in a law firm and created estate plans for individuals who would come in needing help. And I had many experiences with individuals who would come into my office and they would say, we've had this tragic situation. We had something go wrong in our family. We've had a death. We're just so grateful that there was a plan in place because it made it so much easier knowing that we're doing the right thing. Having an estate plan gives you peace of mind, but it also gives your family peace of mind the decisions they have to make are based off decisions that you've made for them. Peace of mind is a huge motivating factor for people in creating an estate plan. Another major motivating factor for many people, particularly parents, is nominating guardians to care for younger children and pets. This gives you confidence in knowing that your children will be in safe hands should the worst happen to you. And guardians obviously apply to children, but they also apply to pets too. Pets can be a key piece of an estate plan. And if you have a pet, you might want to know that should something happen to you and you are unable to care for your pet, you've designated someone else that can step in and ensure that your pet receives the care that you feel is appropriate. So parents of children, parents of pets, having a guardian in place is a key reason to look to set up an estate plan. But estate plans are not just about death. A third motivating factor is planning to handle a potential incapacity during your lifetime. Studies have shown that the majority of Americans will be impacted by incapacity at some point during their lifetime, whether it's their own incapacity or that of a loved one, someone that they may be put in a situation to care for. The majority of Americans will be affected by incapacity. So having an estate plan in place is an easy way to plan for that situation. It can be critical to providing for the desired outcome. And it can also, again, make it easier for your family to respect your wishes. If you're unable to speak for yourself, you cannot give guidance about what you want to happen. So having that plan in place makes it easier for your family to say, we know this was what our dad wanted, or we know this is what our child wanted, or our brother wanted. We know this is the right outcome, and we have the legal authority to make it happen. You give them clear direction and you give them clear authority, and that helps make a difficult situation that much easier. Many people do overlook the importance of incapacity planning and tend to think of estate planning as just about what happens at death. But I've, again, had many experiences where those same people, they come in and they start the process of creating an estate plan, and they're focused on what happens at death. And as they go through the process, they wind up thinking that incapacity planning is really what mattered the most to them. But these are the questions that had the greatest impact on how they were thinking and what they felt was most important. There's the questions again about what type of care do you want to receive? Do you want to be on life support? If so, for how long? Who should make what decisions for you? These are inherently personal decisions, and there's no easy way for any default rule to match your desires. And there's no certainty that anyone else would be able to make the same decision that you would make for yourself. So having that plan in place is the only way that you can ensure that the outcome that you want to happen is the outcome that does happen. Of course, many people think about estate planning and what happens to you, the things you own, your assets, your stuff. And that is the primary motivating factor and a huge consideration that should be accounted for in creating an estate plan. The ability to control where your assets go after your death. You know that you can do almost anything with your assets and choose almost anyone to leave it to. You know, there's some fairly common scenarios. Many people choose to have assets benefit their family and their loved ones, but you can also choose to support a charity or a series of charities, organizations and causes that were important to you during lifetime. This is a great way to continue to leave your legacy after your death. You can also set up your estate plan in particular ways that can minimize taxes, and that will maximize the benefit that you pass on to your beneficiaries. By reducing that tax bite, you're ensuring that those that you do leave your assets to, they get more. And you can help your family more. You can help these charitable organizations more. So tax minimization can be a huge factor for some people. Now, many people do equate estate planning with asset distributions, and it is certainly a large part of what you should account for in an estate plan, but it's not the end all of estate planning. Those other factors of guardianship and incapacity planning, it's important not to overlook those. There's one other thing that I like to always mention, and that's business succession planning. And this is particularly true for individuals who own their own businesses. Business succession planning is critical to ensure that a business does not evaporate at death. Unfortunately, the absence of an estate plan and a business succession plan can lead to a loss of value, and it can impair the inheritance left to your beneficiaries. I've dealt with this in my own practice, where I had, unfortunately, a family come in and their sibling had passed away and didn't have a business plan in place, and there was a gap. And we took the necessary steps to fill that gap and act quickly. But unfortunately, it's not a fast process. And it took just a matter of weeks for the value of his business to fall by 1/2. His customers left and found replacements. So what he passed on to his family was half of what he could have passed on with just a simple business succession plan in place. So if you're a business owner, this is a key thing not to overlook. Business succession planning can be an essential part of estate planning if you have a business to account for. So we've kind of got the why down, why you need an estate plan, what it can do, why it's important, and what you should account for. But what is an estate plan? We've all heard that term, but what does it really mean? An estate plan is basically a set of documents that contains instructions for what should happen if you cannot speak for yourself. It's typically a set of documents. It's multiple documents that might be included in the set, not just one document. An estate plan is not one document, it's many documents in most cases. The documents in a plan will vary, and they should be tailored to meet your particular needs. Each type of document is designed to do one thing very well, maybe one or two things very, very well. And so your plan, your needs might only need to account for just one or two of those things, in which case you might just have 1, 2, 3 documents in your plan. But your plan might also be more comprehensive. If your needs justify, you might need a full suite of documents. And you might have 6 or 8 documents in your particular estate plan. But the key is to realize that there's no one size fits all approach to estate planning. Your needs dictate what your plan should contain, what your plan should say. There are some typical documents that are included in most estate plans, and it's helpful, I think, to cover those documents in a little more detail. Those documents that you typically see are wills, trusts, and healthcare documents. So let's dive in a bit on each of those. What is a will? We've all heard about wills. We've seen them on TV shows or movies and these Hollywood depictions of a will. We all have some idea of what a will is. But let's really start from the basics. A will is a legal document that controls most assets when you die. And a will handles very fundamental needs that apply to everyone. There are 3 primary functions of a will. A will deals with your assets. It determines who gets what, where your things go when you die. A will also deals with your children and pets. It will let you allow you nominate guardians for your children and your pets to ensure that there is a caretaker in place if you are unable to care for your children and pets. And a will allows you to specify your final arrangements. What happens to you after you die? What are your funeral preferences, your burial preferences? What do you want to happen? These are the 3 critical functions of a will. So these are purposes that have to happen. These are essential functions. These decisions have to be made. If you have assets, they have to be distributed when you die. If you have a child, someone has to care for them. Your remains have to be disposed of. So what happens if you have no will? Dying without a will is known as dying intestate. That process, again, is known as intestacy. Unfortunately, if you don't have a will and you do die intestate, it doesn't mean that these questions aren't answered. It simply means that you have no say in these answers. Again, these are matters that have to be addressed, even if you don't have a will. So instead, what happens is state law will step in and fill in the gaps and make decisions for you. Every state has a law that says if someone dies without a will, here are the default assumptions and the default decisions that are made for them. And this is one of the most common misunderstandings that people have. Many people assume that these default state laws will give the same results that they might have chosen for themselves with a will. And that's unfortunately not always the case. And a quick example, I think, really helps to clarify this point. Let's just assume that there's an individual who's married and has 2 children, and they die without a will. Well, a typical state law might say that if you die without a will, your assets are divided equally between your spouse and your children. Oh, that sounds great. That may be what you want. You want your assets to pass to your family. But if you look at that state law just a little bit more, you realize that it's actually divided 1/3 to your spouse and 1/3 to each of your 2 children. That may not be what you want. Maybe you wanted everything to pass to your spouse and your spouse to care for your children. And you might be very surprised if your spouse is unable to maintain a house or maintain a standard of living with only 1/3 of the assets from your estate. Unfortunately, that can actually put your spouse in a very difficult position financial strain. And unfortunately, there are common situations where they have to take out an additional mortgage or even sell the house because they can no longer maintain payments or maintain that household. So although the state law at first glance, it looks like, yes, that's what I want. I want to care for my spouse, my kids. I want to care for my family. Once you start to look at those details, it becomes clear that relying on those default assumptions is not always going to provide the result that you would have chosen for yourself. That's why it's so important to have a will so that you can make these decisions, so that you can say what you want to happen for your family. And you're not relying on a legislature at some point in the last 50 years to say what should happen for you. So let's focus a bit more on how a will works after death. Wills go through a process known as probate. Many people have heard of probate. We have, typically some association with it, but it's a probate process. It's a judicial process that goes through court. And the primary role of probate is to determine the validity of a will. The probate process is also where the executor is appointed to carry out the terms of the will. So you died, your will goes to court, and the court looks at it and says, this is valid. This meets the minimum requirements. It is written, it's signed, it's got 2 witnesses. There's no indication that it's fraudulent. So the court gives it its stamp of approval, says this is a valid will. Let's appoint the executor to continue this process and carry out the administration of the will. That's probate in a nutshell. The executor plays a critical role there because the executor is the person who is responsible for the administration of the will after death. And the executor has 3 primary functions. They collect assets, they pay out any debts or expenses or taxes, and then they distribute the assets that remain to the beneficiaries. So they take assets in, they pay out expenses, and then they make distributions out. It sounds like a really simple process, and it should be, but unfortunately it's not. Probate is often undesirable, and that's putting it gently. You may have heard of probate. You maybe even have dealt with it or had a family situation that's gone through a probate. If so, you'll not be surprised to hear that probate can be absolutely terrible. I say undesirable on the slide because it does seem better to say undesirable, but terrible is probably a better description of it. Sometimes it's just a little burdensome, but sometimes it's absolutely disastrous. And I've seen it play out a lot of different ways, but it's always in varying degrees of how bad it is. I've never heard of a probate experience being good for anyone. Sometimes it's a little bad, and sometimes it's a lot bad, but it's always bad. It's always bad. It's never good. And I'm really emphasizing that point because probate can be absolutely disastrous to a family. So what makes probate so bad? Well, the first thing is it can be incredibly slow. Here in California, 12 to 18 months from start to finish used to be the standard. But with the lingering impacts of court shutdowns due to the pandemic, it's likely that you're looking at 24 months or longer now. So that's 2 years after death before the probate process is completely wound down. That's assuming no major delays, no litigation, nothing going wrong, nothing popping up and courts not shutting down again. Everything goes smoothly. 24 months is realistic now. That's a very long time to have your family left in a period of limbo. Having assets potentially held up in the probate process. Maybe assets aren't paid out to beneficiaries for up to 2 years. That can be a very difficult period, and it's a very lengthy period to deal with. On top of that being slow, it's difficult and stressful. You have to realize that the probate process begins almost immediately after death. And this is during a period of grieving a loss of a family member or a loved one's. The last thing that anyone really wants to do during this period of grief is go interact with lawyers in a court system and start filling out paperwork. It's administrative hassle. It's a lot. And unfortunately, you see that people are typically already at their last nerve. They've exhausted all of their patience and capacity dealing with the emotional burden of a death. And then this administrative hassle on top of it is just sometimes too much. And it often brings out resentment and can lead to disputes. It sounds small, but it's these disputes are typically like deep-seated resentment. I've seen situations where after a death of a parent, it's the 2 children who are now grown adults, 40 years old, who are starting to fight over Christmas presents when they were 8 and how one of them got more, and parents, should be equalized now. And these things, they're not relevant to the probate process, but they're things that come up in the probate process. And it can lead not only to a dispute or litigation, but it can lead to strife within the family. And unfortunately, it's not uncommon to see a family who goes through the probate process and their relationship afterwards is just never the same. It stresses the family relationship in ways that sometimes are irreparable, and just you cannot go back to the way things were. But on top of being slow, it's stressful, it's expensive. Probate can be incredibly expensive. A $1 million estate in California can have up to $50,000 of fees. And these are statutory fees that if you're going through the probate process, you may not have many options to avoid these fees. You can have some options, but if you hire a lawyer, the lawyer is legally entitled to their cut of that fee. $1 million is a lot. So 50,000 over $1 million, let's focus on that million for just a second, because that $1 million includes the full value of the house. That's the gross value, not just your equity. If you've looked at real estate prices in California lately, you've seen that they're going up, they're high. It's quite common to have some individual who you may consider, stable financially, but not by any means wealthy, but they own a house that's worth, let's say, $800,000. No, they don't have $800,000 of equity, but their house value is $800,000. Most of that they still owe on the mortgage, but you don't account for the mortgage in probate. That full $800,000 value gets added into the total value of their assets. You start adding in a few other assets. You have, a house, some savings, maybe a business, and you'll see that it's pretty easy to get to that $1 million. Again, someone that may not be deemed very wealthy could easily have $1 million of a probate estate. That situation arises, they're forced to pay $50,000 of fees to go through probate. Unfortunately, they may not have $50,000 of cash available. And there are situations, again, where you see individuals who have to take out an additional mortgage or take out loans or sell assets simply to pay for the privilege of going through probate. It's almost ludicrous when you think out of how it costs $50,000 to go through this truly horrible process, but that's just how the laws are set up today. So probate avoidance is clearly something that we should all be looking for. If you're going to go through probate and it can be that bad, what can you do to avoid it? And probate is so bad for so many people that avoiding probate itself becomes a major reason to create an estate plan. And that's one of the key reasons that many people will look to create a trust. Wills go through probate, so look to a trust to avoid probate. So what is a trust? Many people have some association with a trust. They've heard of a trust or trust fund babies, or the Rockefellers or the Bezos families, the Gates family, these wealthy individuals. They certainly have trust, and trust are tools that are used by the wealthy, but they're not only for the wealthy. It's not all about money. So let's kind of start with covering what a trust is, as there are many understandings of what a trust is, what it does, how it works. A trust is a legal agreement between three parties. There's the settlor, which might also be known as the trustor or the grantor. This is the person who creates the trust and puts their property into it. The second party is the trustee. This is the person who holds and manages the assets in the trust. And the third party is the beneficiary. And this is who the trust is held in favor of. So basically, the settlor creates a trust. They give their assets to the trustee to hold for the beneficiary. If you're a visual person, it's a triangular relationship, but that three-party relationship is really the essence of what a trust is in at least the legal view. Now, in most cases, the settlor, the trustee, and the beneficiary, those three roles, those are the same person initially. You create the trust, you're the settlor, you put your assets in, you hold them as trustee, and you hold them for your own benefit as beneficiary. So initially, you fill all three roles. But over time, those roles can split. Different people can fill in different roles, particularly after death. So you create a trust and you die, someone else will become trustee, and maybe your children become beneficiaries. So it's important to recognize that those three roles are separate and they can change over time. And that's where the value of a trust really exists. So why would you use a trust? What's the purpose of a trust? Well, there are many reasons to use a trust. There are many purposes for trusts. The first as we've just discussed, is to avoid probate. And this is key for many people. We've just talked about how wills go through probate and how probate can be bad. So if you want to avoid going through probate, you can look to use a trust. Rather than building your estate plan around a will as the central document, you can build an estate plan around a trust. Trusts do not go through probate. I'll say that again because it's really important. Trusts do not go through probate. So you can use a trust to avoid all of those negative consequences of going through probate. If you rely on a will, the will goes through probate. But if you rely on a trust, the trust avoids probate. But a trust is not just about probate avoidance. The trust also gives you more control over when and how assets are distributed. This is key. This management and distribution of assets is key to how a trust structures, how a trust functions, and how you set up the trust to achieve your overall estate planning objectives. A trust also applies both during lifetime and after death. And this means that a trust can be useful in planning for incapacity and can ensure that there's a seamless transition of control if something happens to you and you're still alive, but unable to make decisions for yourself. Again, we started off by discussing how the majority of Americans are affected by a period of incapacity. The trust is a key way that you can help account for that. The trust also allows you to provide for your family. And this is a big motivating factor for many people with younger children or people who might be in blended families or second marriages. Trusts give you more control over assets that will eventually benefit your children, particularly if they are young children. You may not want them to receive assets immediately today, but you can still pass assets to your children and they'll get them later when they're more responsible, more mature. Trusts also give you more control over providing for your spouse for his or her lifetime after your death, but then ensure that your assets ultimately pass to your children. So you may not want to worry about giving assets to your spouse and then your spouse remarrying or your spouse redirecting those to their children instead of yours. So a trust allows you to ensure that your objectives of caring for your spouse, providing for your spouse, and then ultimately providing for your children, those objectives can be carried out through a trust. Trusts also allow you to minimize taxes. This is less of a concern for many people today, given the relatively low estate tax threshold, but there are lingering concerns about a tax overhaul that could change this. Currently, most people don't have to pay federal estate taxes until they're over about 12.5 million of assets. Most people are not worried. You get to combine those for spouses, so $25 million for a couple. Yeah, you need to worry about federal estate taxes. But if you're under that threshold, today it's not really on your radar. Now, if those thresholds change and that's lowered to maybe 2 million, that would be a drastic change, but obviously many more people could be affected by estate taxes. So trust can be useful for tax planning mechanisms. Most people don't need to worry about that, but given that there is always that potential for tax changes in those tax laws, it's important to realize that a trust can have that benefit. Now, trusts are managed by a trustee. This is somewhat comparable to the executor under a will. The executor is the person who is responsible for administering the will after death. The trustee is the person who administers the trust. The trustee, it may be easy to think of them like the CEO of a trust. Now, the trustee, they are bound by law and the terms of the trust. So the trust says what the trustee has to do, or maybe the law says the trustee can only choose these certain things. The trustee is not someone who has unlimited discretion over how these assets are held and managed and distributed. They can't, for example, pay for their own family vacation out of the trust assets. They have to use it for the purposes that you specify in the trust. But it's still a critical role, and the trustee is someone who still has to make very important decisions on your behalf. This trustee can also work with other professionals and advisors, so they can consult or hire their own lawyers and their own financial advisors, their tax planners. They can have other individuals support them and assist them in making these decisions. But ultimately, the trustee is responsible for making these decisions for the trust. So when you choose a trustee, it's important to realize that you need to choose someone that you trust. The trustee it's very much in the word itself, but it is a role of trust. But you also need to choose someone with the ability to carry out these duties, these administrative duties, maybe some legal filings or tax filings. Sure, they can work with a lawyer or a tax accountant to file these and carry these out, but you need to make sure that the person you choose is comfortable with those obligations, whether they do it themselves or work with a financial advisor or tax planner. They need to be comfortable in carrying those out. Many people choose a spouse or their children as trustees. Some people choose relatives or even their close friends. These are all great options. What you choose should be tailored for your situation. What I choose and what your neighbor chooses are not relevant. They may be helpful for you to understand who you could choose, but ultimately you need to choose someone that's right for your needs. And it's important not to overlook that you can choose a trust company or a professional fiduciary. There are individuals and companies that exist to serve as trustees. So if there's not someone in your family, if you aren't comfortable naming your children, or you don't have another relative that you want to put into this position, or if you fear that there could be a dispute or disagreement amongst your children, naming a corporate fiduciary or professional fiduciary is a great option that you might want to consider. Now, when we talk about trust, it's important to pause and realize that there are many different types of trusts. The type of trust that we've been discussing is the revocable living trust. And this is the most commonly used type of trust. It is the workhorse of modern estate planning. When most people think of a trust, they are thinking of a revocable living trust. Now, a revocable living trust, the name itself gives you a little bit of information about it. It's created while you're alive. That's the living component. It's a trust that you create today while you are still living. It can also be changed, amended, or even revoked during your lifetime. That's the revocable part. So you create a trust, but it's not permanent. It's not set in stone. You can update it. It can evolve with you. And again, the key benefit of a revocable living trust is that it does avoid probate. Another type of trust that you may encounter is a testamentary trust. And this is less commonly used, but it's still something that you may have encountered. This is a type of trust that is not created while you're alive, but it's created under the terms of your will. So your will might specify that upon your death, to create an asset, or to create a trust, and your assets go to that trust. This is only effective at death. That makes it a little bit easier to create because you're just creating it under your will. You're not having to do anything today. But because it's created under your will, because wills go through probate, testamentary trusts typically do require some form of probate. So it may be a little bit easier today, but it may be a little bit harder later on if it does require going through probate. There are some other types of trusts that we have listed on here. One is trusts that are used for tax planning, and these come in various forms. And credit shelter trusts, Q-tip marital trust, irrevocable life insurance trust. There's all sorts of names and acronyms that you might have heard of. These are all special use trusts. These have very specific objectives. So if you have a specialized tax need, odds are good that there's a specialized trust that will help you achieve that objective. But these types of trusts are used, again, for special purposes. These are not used in general estate planning like the revocable living trust is. These are used for very specific purposes. There are other types of trusts that you might see for other special purposes other than taxes. And, one example is a special needs trust. And this is a type of trust that might be useful if you have a beneficiary who may have additional needs that qualify for governmental support benefits. A special needs trust allows you to leave assets to that beneficiary without risking that they lose their eligibility to receive governmental support and assistance. Again, it's a very specialized type of trust to use in a very specific situation. If that is your situation, you should be aware of that because that type of trust does exist and it can be useful. But a special needs trust is not a substitute for a revocable living trust. A revocable living trust is a general purpose trust that's commonly used in estate planning. And tax planning trusts or special needs trusts are very specific tools for very specific situations. The other things that you might see in addition to a special needs trust are things like an asset protection trust or Medicaid planning trusts. Again, the takeaway is that these are specific tools to accomplish specific objectives. And if you have these objectives, you should consider these. But these are not a situation where you might say, I don't want to create a revocable living trust. I want to create a special needs trust instead. They're not alternatives. They're different use cases. So it's important to be aware of them. But most people, when they think of a trust and when they talk about a trust, most people are thinking of a revocable living trust. So one of the most common questions we get at Trust and Will is, what is the difference between a trust and a will? Well, trust and wills have a lot in common. They have many similarities and they have many differences as well. The important thing to note is these are not true alternatives. Each one does some things that the other one does not. It's not necessarily a hamburger or a hot dog. So what they have in common is both a will and a trust. They both allow you to dispose of assets after your death. That's a key piece of estate planning. And these are two different approaches of how you do that. But the differences are very important as well. And we've covered that trusts avoid probate and wills go through probate. That's a key difference. If you're looking to avoid probate, you might not want to build your estate plan around a will. You might want to focus on a trust. Trusts also give you greater control over when and how assets are distributed. If you have younger children, that might be particularly important. Or if you want to just stagger distributions over time, a trust gives you that control. A will gives you less control. Wills can be a little bit easier to set up during lifetime. Trusts require a little bit more work. If you create a trust, you have to transfer assets to the trustee. That's an extra step that you have to take with a trust, but it does give you that benefit of avoiding probate. Excuse me. Wills also allow you to nominate a guardian. Excuse me. Wills allow you to nominate a guardian and specify your final arrangements. Trusts don't do that. Trusts do not deal with guardian nominations or final arrangements. So that's an important point, that wills allow you to specify guardians and final arrangements, but trusts do not. So those functions are essential, and everyone should have a will that addresses those functions. So it's not really a question of, do I need a will or a trust? Those functions of a will are essential. Everyone needs a will. Everyone needs a will. Some people also need a trust. If they have additional needs that a trust might help them advance, they might also need a trust. But everyone needs a will. So it's not a question of a will or a trust. Everyone needs a will. But some people also need a trust. They're typically paired as a set of a trust and a will together. It's not a question of will or trust. It's a question of, I need a will, but do I also need a trust? Excuse me. And so what might you want to consider in answering that question of, I need a will, but do I also need a trust? When should you consider also having a trust? Well, one situation is having younger children. Rather than having all of your assets go immediately to your children or when they turn 18, a trust lets you set triggers for asset distributions. And these can come in many forms. It could be ages or life events. When your child turns 25 or when they graduate college or have their first grandchild. These are things that help you stretch out distributions. A trust is also useful if you have more complex family dynamics, blended families, second marriages. We spoke earlier how trust can let you benefit your spouse for your spouse's lifetime, but then still ensure that your assets ultimately protect and support your own children as well. That these assets are not redirected to a second marriage or a stepchild. Trusts give you a little bit more control over privacy. After death, wills go through probate. Probate is a court proceeding and it is public. So wills become public after death. Trusts do not. Trusts avoid that and they stay private. Now, is it likely that someone's going to go down to the courthouse and look at your will, find those court records and dig through your will? Maybe it's not likely, but it could happen. So if you're focused on privacy, a trust gives you a little more control over privacy than a will does. Trusts are also particularly useful if you do have higher asset levels. There's a few ways that this can play out. First is probate avoidance. In California, you're at about $160,000 when probate starts to be required. So if you're over $160,000, probate avoidance is relevant. But then again, as your asset levels increase, the cost of probate also increases as well. So when you get to 500,000, probate's more of a concern than at 200,000. So as you get higher asset levels, probate avoidance is more of a concern. If you get to very high asset levels, close to 12 million for an individual or 25 for a couple, estate and income tax minimizations start to be more relevant as well. Again, this is very few people will be affected by this, but it's important to note that it could be something that could shift in the future. So we note it even though most people aren't affected by federal estate tax. Trusts also give you opportunities for more advanced planning. You can give charitable planning and structure things and give you more control over exactly what you want to happen with the trust. So if you have very specific needs that you feel very strongly need to be carried out, a trust typically gives you more control over that. And lastly, a trust can be useful to help stretch out retirement distributions more than a will. So if you have retirement savings that you plan to leave to your beneficiaries, a trust may provide you a more tax-advantaged way to distribute those retirement savings over time, helping stretch those tax savings and those tax benefits a little longer than you might be able to without a trust. So we've covered wills and trust, and we discussed earlier that there are three primary sets of documents, and the third one that we haven't spoken about is healthcare documents. So let's talk a little bit about healthcare documents. There are typically three types of healthcare documents: a power of attorney, a healthcare directive, and a HIPAA authorization. A power of attorney is a document that allows you to designate someone else to make financial, non-medical decisions for you. This is typically used in the event of incapacity, but it can be set up in various ways. So if something happens to me, I am unable to make my own decisions, the person I appoint, the agent under my power of attorney, can act on my own behalf. And that includes things like paying my taxes, paying my property taxes, paying my mortgage payment, dealing with banks, anything that's financial, non-medical. A living will, also known as a healthcare directive, is very similar to a power of attorney and that allows you to designate someone to make decisions for you. But with a living will healthcare directive, those decisions are limited to medical decisions. Now, a living will also does one extra thing. It allows you to specify your own medical preferences in advance. So I can say what I want to happen for my own medical care, for my own medical treatment. I get to specify that, but I also get to choose or designate someone else who can make additional choices for me. So that living will healthcare directive, it covers the medical side of your needs, whereas the power of attorney covers the non-medical sides of your needs. The third healthcare document is frequently overlooked, unfortunately. It's known as a HIPAA authorization. Many people are familiar with HIPAA. It's a federal law that restricts what healthcare providers can do with your medical data. It's what limits your doctor from talking about your medical condition while he's playing golf. But a HIPAA authorization allows you to ensure that your designated agents and representatives can speak with your medical providers. They can make decisions. They can consider the cost of treatment. They can get the information that they need about your medical needs so that they can carry out their roles as your agent. This HIPAA authorization, it is unfortunately frequently overlooked, but it is a very important piece of estate planning and helps make it that much easier for your decisions to be carried out as part of your estate plan. So who needs an estate plan? Well, that's pretty simple. There's a lot of words on this slide, but everyone needs an estate plan. Every adult needs an estate plan. Every adult needs an estate plan. Everyone over the age of 18 should have an estate plan in place. Now, realistically, on your 18th birthday, getting an estate plan set up is not really the top priority. So it's not common for an 18-year-old to have a plan in place. They should, but they don't. So what are the things that actually motivate someone to get an estate plan? There are a few. As people get married, they suddenly have someone else they need to care for. They look to create an estate plan, put a plan in place. Or if they have children, now they have a family that they're caring for. Having children can be a primary motivating factor to put a plan in place. But separate from that, as you start to accumulate assets, maybe you're becoming more successful and established in your career, you now have more things that you need to account for. And what happens to those things? Do you want to support a charity with your stuff, whatever it may be? It becomes a little bit more relevant. You can start having an estate plan in place. Or if you have a medical concern, something in your own personal situation that requires you to be just more aware of your medical needs, that's a good time to look at having an estate plan in place, whether it's to deal with potential death or even just to set up those healthcare documents so that you have your decisions made and you've designated those who could speak on your behalf. Unfortunately, many people put off having an estate plan until they are in the process of dealing with someone else's death, whether it's a friend, a coworker, a loved one, a family member. Dealing with someone else's death is a primary motivating factor for many people to finally get started with their own estate plan. And lastly, approaching retirement. So as you get to the point where you're starting to say, okay, I'm settling out of my work age. I'm looking to retirement. I need to have a plan in place because my life is changing. This is a major overhaul of my life. It's time to put a plan in place. If you don't have one by then, that is certainly the time to have one in place. But estate planning is not a one and done situation. Your estate plan should evolve as your life does. You should update your plan whenever your needs change. So if you need to update your beneficiaries or change your guardians or change your agents under your power of attorney, then you need to make an update to your estate plan. And as your kids get older, that might be a time that you want to look at changing your guardian. They may need a different guardian. Maybe the person you appointed to care for a young child isn't the same person that you would choose to care for a 16-year-old. But there are also some very common triggers for when you might want to look at updating an estate plan. And these are major life events. So if you have any births, deaths, or changes in marital status, that's a great time to look at updating an estate plan. But even if you don't have any of those major life events, it's a good idea to just take a look at your plan every 3 to 5 years. You may not need a change, but just take a look to make sure everything still matches your needs. Because over time, your needs will change, but also over time, the laws can change. So even if your needs don't change, maybe your plan still needs to be updated to comply with the evolving laws. So again, after major life events, births, deaths, changes in marital status, or every 3 to 5 years, it's a good idea to at least look at your plan and make sure that it doesn't need to be updated. And if it does need to be updated, go do it. Because having an out-of-date estate plan is not helpful. You need to make sure that your plan evolves as your life changes. There's also a point on here that as children become adults, they need their own estate plans. And that's unfortunately frequently overlooked. While your child is under 18, you have parental rights. You can go speak to their doctor and learn what's going on, or you can get information on behalf of your child. But once your child turns 18, they need to have legal documentation in place to let you act on their behalf. So they need their own estate plan. They need to designate you as their power of attorney, for example. And this is a document that your child would put in place. But as your child grows, it's important to realize that they need their own estate plan as well. And planning is not just about you, it's about ensuring that your family is protected as well. So if you do have young children today, as they grow older, don't overlook that they need to eventually consider having their own estate plan. And you can be the person that helps make that clear to them when they turn 18. So we've covered what an estate plan is and why it's important to have a plan, but how do you go about getting a plan in place? Well, there's always the old-fashioned route of finding a local estate planning attorney. I did that for many years, and it works for many people. It doesn't work for everyone. Sometimes it's hard, sometimes it's expensive, but it's a great option, and it will meet your needs if you can find an attorney that meets your budget and your preferences. There are also other options like trust and will that provide you with the tools to create your own estate plan. So trust and will, we were born from the recognition that the traditional way of creating an estate plan was not working for everyone. There were some people who put off having a plan because they couldn't find a lawyer. They couldn't afford a lawyer. So the process was expensive and confusing, and many times it was just intimidating. And that left many people with no plan in place, or plans that were very outdated. People were just confused. They didn't even know where to get started. So Trust and Will, we started a different route. We embraced technology and developed an easy and affordable way to create high quality, fully customized documents that are on par with those traditionally created by attorneys. The easy way to think of it is in many ways, we're like the TurboTax of estate planning. We offer 3 different tiers of products. We have a guardian plan that's useful for parents of young children who are looking simply to designate guardians. We have a will-based plan, which allows you to create a will and a set of healthcare documents to cover those standard core essential estate planning needs. Then we also have a trust-based plan, which is the more comprehensive plan that adds that revocable living trust. And that provides you, again, with that probate avoidance, greater control over planning for younger children, and potential tax planning. All those benefits of a trust really come in with the addition of that trust. We also offer attorney support. We have a plan to offer individualized review, guidance, and advice from a licensed estate planning attorney to ensure that you understand how your plan works and that you know that it's the right plan for your needs. We are live in California on that. We cover about a third of the population, but we're continuing to expand that attorney support over time. But where I really like to emphasize Trust and Will's value is that even if you just want to learn more about estate planning or figure out what's best for you, you can always head to trustandwill.com and just look for that learn link at the top of the page. We have a wealth of information about estate planning, what you need to know, how to get started, what you need to, how to decide what plan's best for you, what you need, what information you need to get started. We also have representatives that can chat with you if you have any questions about the process, or if you have any, if you want to go over any questions. We have agents that can help you with that. But even if you're just looking for information and you say, I don't know what my next step should be, you can always learn from Trust and Will. Even if you want to take that information and go find, a lawyer, some other way to create your estate plan, we consider that a success because we exist to make it easier for everyone to have an estate plan. And if we do that by providing education, then we consider that a success. So I really encourage people to utilize those resources to learn more about estate planning and learn what they can to help make their process of engaging with their estate plan that much easier. And when you are ready to get started, you can always visit the site calcoastcu.org/estate planning. It's on your screen. There's a hyphen between estate and planning, but it's on your screen. And you'll get 15% off any estate plan from Trust and Will. We're very grateful for our continued partnership with CalCoast, and we are honored to be able to offer that discount to all CalCoast members as well. So I know this is a lot of information that we've covered today, and I hope we've covered the basics to give you a better understanding about estate planning, why it's so important, and what you might need to consider when creating your own plan. If you do have any other questions, you want to get started in this process, CalCoast is an excellent resource for you to help connect the dots between your estate planning and your overall financial health. I know Josh can give you a little more information about that. Any websites to reach out to get started with that. I also want to check briefly. I'll stop sharing my screen so I can look and see if we have any questions along the way that haven't been answered. But let me pause and do that. Josh, if you want to step in, feel free.
Excuse me. Absolutely. Thank you, Patrick. Yeah, we do have a few questions in the Q&A box if you want to take a look at those. And there was one in the chat I'm going to go back to in just a second here. But I do want to mention, that was a great segue. Thank you, Patrick, for all the great info and talking about other resources we have. CalCoast has a financial wellness platform, and it's powered by Enrich, but it's a CalCoast branded site. And what it is basically information on any topic that you can imagine in regards to finances, budgeting, credit scores, investing, retirement, debt, estate planning, long-term care, whatever's on your mind, you can find info about it on this platform. And it's in the form of articles, videos, tools, courses you can take. You can even take an assessment, and it'll create kind of an individualized experience for you. It's really cool. It's free. So I'll post the link in the chat for that. Again, it's powered by Enrich, and it's really cool. So I encourage you to check it out. One of the questions, Patrick, that I just want to make sure we don't miss the opportunity to answer this here was, when should you change a revocable trust to an irrevocable trust? And do you need an irrevocable trust if you gift your assets away to protect them from reimbursing long-term healthcare costs?
Yeah, that's a great question. So revocable living trusts, again, the general use workhorse of estate planning, and irrevocable trust is almost always going to be a specialized tool. So those tax planning trusts or the special needs trusts, many times those are irrevocable trusts. Those are not typically interchangeable. So if you have a revocable living trust, it serves one set of purposes. And if you want to create an irrevocable trust, it's typically for a very specific reason. One reason could be for qualifying for or avoiding having to repay for Medicaid type benefits while you're alive. That's a particular type of trust known as a Medicaid asset protection trust. There's lots of different names that are all that similar concept. If you have that specific need, then that specialized tool, that irrevocable trust, might be for you. But it's not always going to be for everyone. So there's never really a situation where we need to convert from revocable to irrevocable. You might need to add that tool if you have a particular need you're trying to solve for.
Right. And then I know there's some other questions in the Q&A box. Did you want to take a look at those, or I can read them off to you either way?
I can do that. So the first one we have here is about estate planning and liability or asset protection. That's a great question. Most revocable living trusts have minimal asset protection benefits. That's not one of the things that a revocable living trust is designed to do. Asset protection is a specialized need. And in order to have asset protection, you typically should be looking towards a different type of trusts. Now, what you should also bear in mind is that you do gain asset protection and creditor liability protection, but you may give up some control of your assets particularly if you're trying to look for protection against your own creditors. So it's something that if you are concerned about it, if you work in a high risk industry, or if you have another concern, that's something you might definitely want to bring up if you seek a consultation with a lawyer. But revocable living trusts are typically not used for asset protection purposes. The next question is about the breakdown of people in California who die with a will versus those that die without a will. That's a great question. I don't actually know that figure. I would have to look at that. If you want to reach out through Trust and Will or send someone an email, we can certainly follow up. Josh, if you want to email you, if you want to email contact at Trust and Will, we'll get you that information because it's knowable because of the court records. We can look and see how many probate court cases are filed as testate with a will or intestate without a will. I don't have that figure off the top of my head, but it is knowable. If I use my will to assign a guardian for my kids, will they be placed in foster care for 24 months while in probate? No, that's a great question. Typically, guardians would be appointed as almost an emergency step at the very beginning of probate process. There can be a very brief gap, particularly if there's any doubt about the validity of your will, or if the will isn't located early on. So having a guardian in place a guardian nomination in place is an essential function of a will, but it is not dependent on the full 24-month process. Your children are not going to be left in foster care for 24 months. The administration of the will typically takes 24 months, but some of the intermediary steps, like a guardian appointment, can happen much, much sooner. Can a successor trustee be the public notary that notarizes the living trust? Typically, notaries are prohibited from notarizing documents that provide any benefit to them. So that may be a restriction on the notary who may not want to do that. If you wanted to name that individual as a successor trustee, the simple option might be to just have a different notary notarize your document. But an individual who's a notary certainly could serve as trustee. You might just not want them to also be the person who notarizes the document for simplicity. In terms of helping get notarization, we actually do have some notaries at Trust and Will, and we also have resources to help connect you with local notaries. There are many notaries, many banks, financial institutions, AAA offices often have them, UPS stores. So if you're looking to help find a local notary, you can reach out to Trust and Will. We'll help connect you with resources that we have, or find a notary who's near where you need to find a notary. Can one add assets to an irrevocable trust? That typically is going to depend on the structure of an irrevocable trust. Again, because those are so very specialized tools, it's hard to speak generally about an irrevocable trust, but you may be able to continue to put assets in, but they may be locked as well. So it depends on the specific type of trust and the terms of that trust. The general cost for a trust is their annual maintenance fee. So with an attorney, the cost is going to vary. A trust-based estate plan that includes a trust, a will, and healthcare documents could range anywhere from maybe $1,500 to $5,000 or more. It's not really unheard of to be that expensive. Unfortunately, that's why many people do put off creating a trust with an attorney. Typically, there's no annual maintenance fee while you're alive. After your death, the trustee can or they are entitled to a fee for their services, but there's no annual fee for a trust. With Trust and Will, our trust is available starting at $599 compared to that $1,500 or $5,000 you might find for an attorney. We don't have an annual fee for the maintenance of the trust, but we do have additional services that we can provide as an opt-in basis. So if you're interested in learning more about Trust and Will, I'd suggest you go to trustandwill.com. We have information there, and again, we have agents who can help you out. And I think that's all, Josh, unless there's any other questions.
Right. Looks like Salvatore was asking in the chat, are the fees with CalCoast relatively less? I think that's the discount we offer, right?
Yeah, it is. So that number I said, which is $599 for an individual or $699 for a couple of spouses, those are our full prices. And so the discount that we mentioned again would come off of that. So you would definitely get a lower fee for being a CalCoast member.
Well, yeah, I think that's all the questions we have right now. Thank you so much to everyone for joining us. That was a jam-packed hour of information. Patrick, thank you once again for providing all the info for us. I know that we've just been getting so many thank yous in the chat. A lot of people saying it's very informative. They learned a lot. So this has been incredibly valuable. Thank you for your time. And again, thank you for joining us, everyone. Keep an eye out for our next webinar coming next month. We'll be sending out an email with the date and time and the topic. And you can also find that information on our website at calcoscu.org. But until then, thanks again, and we'll see you next time.